All right, thank you very much. While he's working on that, I can confirm that the facilitators of this particular session have been asked to make a lot of accommodation in terms of time. And we're very happy to do so because I understand the branch is a new branch. They are not getting the sort of support that was expected. Now, while the paper is being loaded, perhaps we can do a bit of an interactive session before the paper is loaded, so we can at least fill our time up with some kind of information. Who amongst us here can thumb their chest and say he or she is a technology lawyer? Because I want to ask a question. Can anyone, you are pointing to someone, how come you are not taking the, oh, you are? Or the both of you? Okay, so let me start with a very basic question then. Some time ago, the company called Google consolidated its operation under a name. What's the name of that company, the holding company for Google? Not you. So I wasn't asking you, I was asking her. So I said, let me start from the little. All right. Second question. Recently, Meta hired the owner of an AI company after it acquired that AI company. The amount that Meta paid for that AI company was $14.2 billion. What's the name of the company and what's the name of the MD? No? So I'll give you the name of the organization. The name of the tech guy, and then you can find the name of the company. It's called Alexander Wang. I'm sure it's only Okpe that could have answered that question. But Okpe is trying to compete with them. All right. Mr. Alternate Chair, how much time do we have? Because I'm running out of questions. All right. So in Nigeria, the central bank recently unveiled a plan to deepen the e-payment systems. What was that plan called? What's the projected period for that plan? And what is the underpinning policy for that plan? Anybody? So we only have just one tech lawyer in the room, and the tech lawyer himself is even challenged. So let me tell you, the difficulty for being a successful tech attorney is not just because you become technical. It's because you are able to withstand information overload. This is an environment where there's a whole lot to consume. That's why niches are forming around tech. People are saying, oh, I'm only going to do crypto. People are saying, oh, even within crypto, I'm going to do digital assets only. It's not because they are not good in others. It's because for you to be able to stay good and solid, okay, the slide is here, you must stay on top of your game. Otherwise, the next guy will take over. My name is Basil Udotai. I don't know if there was an introduction. There's a bit of a profile. I don't know if it was read. I started tech law indirectly when I came in to negotiate the very first government-wide software licensing agreement between Microsoft and the federal government of Nigeria. After that, I was appointed legal advisor of NITSDA. From NITSDA, I was appointed the coordinator of Nigerian Cybercrime Working Group. That was happening, that was at the Office of the National Security Advisor. From the NSA, we started the Cybercrime and Cybersecurity Project for Nigeria. I left government as Director of Cybersecurity. So that's my government background. And then I set up a law firm that used to be called Technology Advisors. And then later on, we merged with other law firms. We're now called Johnson and Wilner. Can I wake us up by asking that you give me a little round of applause? So, who is going to help me move the slides? Okay, go ahead. So, my Lord, this is the framework of the discussion I am planning to have today. So to enable us really dissect this story, I'm going to look at 5 stories, and then I'm going to pose one challenge. The first story is going to be a story about a judge. And then I'm going to tell a story of the court, the judiciary, and justice. And then I'll tell a technology story. And then we're going to question the architecture of the reform that we're applying for our e-judiciary system. Then I'm going to see if we can attempt to reimagine e-judiciary. And then I have a hackathon, I have a test for us to run. So look, it's a legal tech hackathon. It's a challenge. Hopefully we can work together to see if we can build something today. Because you know, I always tell people, my Lord, my sense of AI is that AI would turn knowledge into a commodity. The entirety of knowledge, global knowledge, is going to be collapsed into a subscription model where if you can pay, you would access that knowledge. That, for me, I think, is the outcome, the reality for AI. So if that is true, not only does this question the traditional concept of knowledge seeking, the whole going to school and getting certifications, what it also does is it's going to ask the question, so what do we do now? If all the information I need, I can pay $20 a month and can get it. So what do I do? I mean, what, you know. So my answer to that is now we build. It's a time to build. You're going to be judged on the basis of what you can do, not what you have as a certificate. So that for me is my sense of the reality. How many young lawyers in the room? Young is 1 to 7. I see 1. Only 1, 2, 3, 4. Okay, so this question is for young lawyers and is worth $100. My Lord, I always like to ask a question that has money because that's how you get people's attention, at least in Nigeria. Usually, if the hall is full, my Lord, at this point, everybody will wake up. In fact, in one case, someone said, but what was the question? Someone had to tell her, I don't know, we haven't asked the question yet. So, my Lord, my question is only for the young lawyers. And if young lawyers cannot crack it, then I can move it up a bit to see who amongst the senior lawyers can answer, with the condition that the senior lawyer will turn the $100 to the young lawyer and then pose another question. So the question is, which country in the world used AI to develop its AI policy and had that AI policy shut down by its cabinet, by this national cabinet? Are you a young lawyer? Because of the way you are raising your hand, it's like my $100 is already gone. So your answer is going to be, you're going to mention the country, you're going to mention why the policy was shut down, and you're going to say what next for that country. Is there any mic? Can someone take a mic to her? Or do you want to come forward? Since you're very confident, come forward. My Lord, with the level of confidence, I think my money is already gone. This girl is not going to make this thing interesting at all.
South Africa.
The answer is correct.
Yeah, so they created an AI policy, and the reason why they had to take it down is because in the policy, they saw lots of mistakes, hallucinations, so they came together and they brought it down.
So what next for South Africa's AI policy?
What next? First of all, I think they sacked the people that were in charge. These dollars looks very good. Thank you. They sacked the people.
Go and sit down. You've already gotten your money. Give the mic to him. All right, a round of applause to her. So the answer is South Africa. Please, can you move the slide? You're going to walk intuitively with me and be moving the slide, please. Next slide. I think there should be a lawyer working there to move these things. Yeah, so, all right. So the country is South Africa, and you can look at some of the headlines. The headline news was quite embarrassing. So you use AI to draft your own AI policy. Then the AI had so many citations that were wrong, reference articles that did not exist, creating those articles to organizations who came out and disclaimed that those articles were ever written or published by them. It even cited news media organizations that did not even exist. So this is the reality of AI. And so my question is, if the government of one of the most advanced countries in Africa could not safely use AI to draft its own AI policy, what chances do our judges have when an AI-generated work enters into their court as evidence? I mean, so the idea is that you'll be a bit more understanding that the challenges that our judges are facing, the challenges that Nigeria is facing is not unique to Nigeria. It's challenges of our time. Next slide, Chief. Next slide. I see the young lawyer that did not win the $100 volunteering to do something here. So I really appreciate your diligence. So, yes. So before now, it was very easy for courts to simply interpret human conduct. But now, courts are being called upon to interpret and adjudicate over technology-mediated conduct. In fact, sometimes technological conduct directly, without any human mediation. So the challenge is not that courts today is confronting the changing law as a result of technology. Technology itself is changing reality. What we used to know as a picture is now something that you have to be circumspect before you even accept. Does this person, is it a real person? Does it exist? Even when you recognize the person, was this a true picture or was this created by AI? Next slide. So the South African incident may seem unique. It is quite unique, but countries around the world have suffered all kinds of challenges around AI. I don't know if you've heard of the US Compass. Yes. Compass is a technology that helps judges to determine the potential of a repeat offender. So based on the number generated, the code generated, the judge can now say, okay, this guy obviously, have a chance of being rehabilitated, so we can grant him bail or can reduce his sentence and so on and so forth. This system got into a lot of challenges in the past and have led to realities that are not reflective of circumstances of some of those offenders. But that's not even the question. The question is it constitutional for a judge to delegate this critical aspect of his work to a technology? That's the question. The second case, the Dutch government applied algorithm to determine families that are entitled to welfare. And the technology threw up all kinds of oddities that were not also reflective of the true situation. The situation in in Australia was similar, but China has a beautiful concept with their smart court technology where you can go and just tell the technology, look, this is the dispute you're having with Mr. Udotai, this is the contract that we signed, and so on and so forth. And the system would generate a possible outcome for that dispute based on 1,000 years or so of Chinese jurisprudence. So if you have that outcome and you say, well, you might want to settle this case with Mr. Udotai because 99.99% of all the cases filed up until now was granted to a litigant or a defendant like him. Would you go forward with the case or not? So this is, again, another automated system that sort of challenged the traditional mode of the judicial process. I just had to bring that to your attention. But look, the very first entity in our story is a story about a judge. So this is a judge whose training was physical. Reading was in the libraries. The books were brick and mortar. The judge had manual filings and paper records in his court or her court. Technology was not even optional, or when it was pedant. It was tangential. It wasn't integrated into the work of the judge. Tech competence was never taught throughout the process, not even at the orientation before this judge assumed office. So all the knowledge that our judge has, not my Lord, of course. My Lord is much more savvy. But this judge in my story, the only digital tools that this judge is familiar with is that he or she learned informally, and some that her children or his grandkids would teach her, say, Granddad, this is how you get on Facebook, this is how, you know. So this is our judge, right? But what does the 21st century require of this judge? It requires that this judge reviews digital evidence, makes judgment over AI-generated materials. This judge must maintain and run electronic workflows, have digital case management. You know, we assume that this judge would have a full knowledge of the working of technology. Because when we file our processes, we're not putting a lot of footnotes explaining anything to my Lord. We're just assuming that, you know, the knowledge is there. So the competence, digital competence for a judge has never been more critical than today, than the situation we have now. And digital literacy is now a judicial necessity. Now, this judge should not be blamed for the situation that he or she finds himself or herself, because it's not a reflection of the person, but it's a reflection of the process. And it's not only in Nigeria. This challenge, judges are feeling it all over the world. But I just thought it is best to commence our e-judiciary story from the point of view of this judge, because he is the one that would interpret the laws relating to technology, and is the one that the Constitution is entrusted with the authority to come out with a ruling that must be enforced, that we must all comply. There is no distinction between a matter that has to do with technology and a matter that has not, for purposes of filing in court, as far as I know, even though I don't have the privilege, my Lord, of appearing in courts. I don't do litigation, but this much rumor I accept, that every case goes to court, irrespective of the underlying subject matter. So we're not asking the future judge to be a techie. That's not the requirement. But this judge must be technologically literate. Because understanding a law and understanding the technology to which the law applies may seem different, but it's not. So we have to ensure that today's judge is trained in both. Judge knows the law. In fact, like I said earlier in our discussion, there's no opportunity to teach any judge any law. Constitutionally, judges are legal experts. That's the only authority that is vested on them by the Constitution to interpret the law. So we should be humbled before a judge as far as the legal competence of bringing reality to statutes, right? Now, but being able to manipulate, manage technology systems, and then understanding the nature of technology. In a couple of slides, we're going to see how deep this issue is. Now, having that other competence is something we haven't had to emphasize strongly before, and we should, because both competencies are going to be demanded of our judge. Now, this is another case. I probably should have used this one. Maybe I would have saved my $100. So this is a case also where a lawyer actually filed process in court relying on precedents that never really existed. Very nice sounding. It's an American case against Meta. The court accepted it. The process went on. The detail on how it was uncovered is not published, but the moment the court realized or was convinced that this was hallucination, AI hallucination, of course, the matter was withdrawn. The lawyer involved was disciplined, but this is the reality. It would look good, it would sound convincing, it would sound persuasive. AI will never tell you, I don't know. It will try to give you the answer, and it will use all your historical engagements to prepackage the answer to be so convincing that you'll be like, oh yeah, I thought so. So if this lawyer who we are not told he was a fraudulent, nobody said he was disingenuous, if he could be misled by AI, what are the chances that judges would also not be misled? Right? Next slide, please. Again, the Nigerian cases I'm citing here, some of them are pending in court, so it's just for academic purposes, and I'm not going to touch on the substance of the issues, but we're very familiar with Femi Falana and Meta, that is now on appeal. So here, I'm just going to ask a question that everybody is asking. Was this a platform liability matter? Was it a defamation matter? Was it a data protection strict to sense, or was it a privacy matter? So I think that understanding the true nature of technology would resolve this issue quickly more than understanding the law. So you're seeing a situation where a judge would be much more guided by his or her understanding of the true nature of the technology and then applying appropriate law for the remedy sought in each case. That's all I can say here, because let's leave the Court of Appeal to come up with the ruling, and we'll all be educated on this. The other is this case. Next slide, please. Yes. Is this case where, I don't know which political divide you belong, but a gentleman who was the governor of Kaduna State is being prosecuted for alleged unlawful interception. Again, this is a case pending in court. We can only discuss it for academic purposes. My only comment here is that interception, lawful or unlawful, is a network native oppression. It happens at the network level. And it leaves a whole lot of trails that forensics and interception audit will produce. So my question is that, would the Nigerian evidence system, as we have it today with our Evidence Act, demand the requisite evidence as part of the court process. Because if you want the evidence is there. But do we have a tech-oriented evidence management system that would lead us to that inquiry? Or would this matter just go away and we will not learn much because we are hamstrung by that incapacity? So that's the most I can say here, and then I'll move on. So our next story is the court. So sometimes we confuse these three entities. We confuse the court with the judiciary and then with justice. I think they are connected, but they are distinct entities. You know, the court is an institution, specific level. If you're looking at customary, magistrate, federal or state high court, it has its own jurisdiction ascribed to it by law, have judges, have registry and staff, and so on and so forth. Now, this is where most of our digital reform concentrate in Nigeria, the courts. We forget that the judiciary is a system. The judiciary is an entire ecosystem. It has courts, registries, prosecutors, lawyers, correctional institutions, enforcement. It's an ecosystem. Now, we haven't yet seen an approach that explores this from a policy standpoint. Not yet in Nigeria. We've seen a lot of effort to reform the judiciary, you know, focusing on the various levels of courts to various degree of success. But the next entity, justice, which is like the outcome that each litigant must have or expect as a remedy for going to court, is also something that is challenged by technology. Now, my thesis here is that for us to succeed as a judiciary, we must target our reform across these three elements. Otherwise, we're going to leave something or someone behind. Next slide. At the last NCC workshop for judges, I've had the rare privilege of working with NCC on judges workshop for about 23 years now. I was there at the very first one. I've missed a few, but it is the most consistent judicial engagement that is done by a technology infrastructure regulator in the country. They have not stopped. Even during COVID, they were calling us to say, what do you think? Can we do this virtual? I said, look, what if none of us survive this thing? Can we just allow my lords to rest, you know, while we figure out the COVID thing? So they are that persistent. But during the last event, a couple of weeks ago, here in Lagos, one of the justices asked a question. So how come all our reform is concentrated on the Supreme Court, the Court of Appeal, the federal, and sometimes the state high court? What happens to these young ones, as he said it? He said, these guys at the magistrate courts, you know, the area court, the customary court, they are the ones that are going to come and take over from us. So why don't we ever extend our programs to affect these other entities? And then I just realized there and then that, oh wow, this is actually the most populous environment for access to justice. And so we're deliberately ignoring them for reasons. As an outsider, I am not aware, but I took my Lord's comments to heart, and I said, perhaps in future engagement, I would insist as well that let's look at that level, that we can be holistic in our reforms. So my Lord, the next story is the story of technology. And I asked this question before, is understanding the law the same thing as understanding the technology to which the law applies? The answer is not. You know, so but how do we bridge that gap? What do we do to ensure that judges who make pronouncements or who are given the challenge of making decisions where technology is involved have the understanding to properly apply the statute in point to the story and to the technology for the purpose of either rejecting or ordering the remedy that is sought. How relevant is this question? Now let's look at the technology knowledge gap. As I see it, the courts have no difficulty looking at cybercrime or cybersecurity statutes. The courts have been taking data protection and privacy matters. I'm sure, in Nigeria, we have seen AI-related images or videos lead to cases. The courts are aware of the digital economy. At least I've attended programs where judges are sensitized on that by NCC. The courts have no difficulty interpreting telecoms law, broadcasting, and so on and so forth, even understanding platform governance and content regulation, because they are in law. So once the judge reads it, the judge gets it. It's not difficult for a judge to read and get statutes, because that's what judges do. So my question is, how come the sensitization of judges and training of judges are only always limited to law and policy? And I discovered that today's environment actually demands a bit more. Judges, to be able to come up with rulings on content regulation or data-specific issue across a platform, must know how algorithms work. Judges must have a sense of what happens to data on a platform. Judges must understand how platforms amplify content at scale. Judges should know how AI generates output, and so on and so forth. I'm sure if you pull a judge, of course, again, our Lord here, and say, what is crypto? The judge's understanding of crypto would probably be like most of us, just limited to money, the alternate source of funding, and the fact that it's not allowed in Nigeria. There are some laws that are, regulations that, are coming out that might allow it as this and that. But I don't think you can have like a real serious engagement with this judge on how crypto is related to what is called distributed ledger, how smart contract is implicated, how is it that they are, what is digital asset in relation to crypto, what is tokenization, and how is blockchain, brought into this story. It will be difficult to have a typical judge, engage on these issues. But that doesn't stop our court from assigning cases to this judge and giving this judge the responsibility to come up with rulings that must be enforced, rulings that commercial predictability somehow lies in. To my Lord, now I move to the architecture of reform. And the question here is, does the model of judicial reform that we embark on in Nigeria up until this moment, does it align? You're doing very well in moving the slides. I applaud you. Does it align with the nature of technology? So to answer that question, I'll introduce you to how technology works. So typically, technology has a hierarchy of layers. The first layer is the infrastructure layer. That's like the foundation. On top of infrastructure, networks are built. On top of networks, you have systems. And on top of systems, you have applications. I can tell you that 90% of our judicial reform in Nigeria have concentrated on the application level, because that's where the interface happens. That's where my friend Law Pavilion locates, because it gives you access to content. It's all application, right? So what happened to infrastructure? We're talking about identity earlier. Nigeria's identity infrastructure is not integrated into our judicial system. So it's still a question out there that, oh, who is this guy? How old is he? In court. But the information is there. How about networks? Is our courts, our courts, even this particular level, are they connected in a protected, secure network amongst themselves? Let's just take Federal High Court. Is there, my Lord, of course, you're going to have the chance to educate us on this, but is there a private network, secure, that connects all our courts together at any level? Right? Are there dedicated systems that are made for the judiciary? Right? Or is everybody accessing technology service through the application layer? Do we feel that having access to judgment on time that is electronic is e-judiciary? Is that our thinking? Because for you to do anything digital, you have to replicate the true nature and architecture of technology. You have to point to an infrastructure. You have to point to a network that you've built on top of that infrastructure. You have to have systems and connected systems. And then at the application layer, you're going to issue what is called APIs. And then have people like Okwe connect, have other people connect. That's the robust level where everybody interacts. So someone is going to do identity service for you. Someone is going to do payment service for you. Someone is going to do all kinds of, but you have to have this architecture followed. Otherwise, you're missing something or you're not taking everything on board. I hope this makes sense, because somehow I feel like I'm talking to myself. All right. Now, since we have seen that we can reflect the nature and architecture of technology in our judicial reform, then perhaps we can attempt to reimagine our e-judiciary. For me, the main requirement, my Lord, the main single most crucial requirement for e-judiciary in Nigeria is what I call the business of the judiciary services. The business. Because this is an environment where there are so many processes. There are so many intermediating processes. People make photocopies, people get CTCs, people file processes, people do all kinds of things. People go straight to an oath to get an affidavit, and they pay minimum fees here and there. So there's an incentive, there's a commercial incentive, there's an economy within the justice system. Now, until there's a policy that tries to mimic what the CBN did with fintech and have a regulated justice system environment, we are not going to touch or solve our e-judiciary challenges. So that's my first recommendation. Let's have a national e-judiciary transformation policy. But let's look at turning all those commercial incentives into a business and licensing operators or service providers so that in reliance of the license, they can go out and get funding and develop businesses that everyone can access. It doesn't matter what. Even if it's building a database, the very first and the most crucial will be to build a database of all court records. Because the judgment is just an output. What comes out of court is, I'm interested in seeing how the cross-examination went in full. And I want to direct my query to how the cross-examination happened in full. I want to stay in America and access that for any case I'm interested in. I want to see the original filings. I want to see the reply. I want to see, this is what constitutes court records. And I don't think you can access it. And you don't get it by getting the judgment. No. That's not reform. In fact, that's not the approach that any sector that conducts reform takes. If it is, then we will not call it reform. I talked about how NCC has done 23 years of judicial workshop and sensitization, and it's an excellent legacy. But recently, even NCC started thinking, the judgments that are coming out of court doesn't seem to reflect these years of knowledge sharing. So how come we're still getting judges say something that doesn't really align very well with how we think of telecom regulation in this aspect or in that aspect? How come judges are allowing people to be joined in matters that really has nothing to do with these people? So perhaps my lords are being confused about the technology side of this thing. So what if we decided, in addition to this sensitization we do and this workshop that we do for judges, now isolate a few judges who are either interested in this subject matter or who, like my lord, is savvy, and say, let's start a certification system where we can say, this is understanding of tech. Teach algorithm, teach networks management, teach network operation, teach things like call origination, call termination, teach roaming, teach interconnection, teach so that judges understand these things like we technology lawyers do, and can then engage technology service providers through their processes and litigants. And so because we have these few judges who across levels of court will be certified, they would now be the channel through which technology cases are sent. And so in this way, you're going to refine our jurisprudence. You're going to see, because the judges are now real experts of the technology law in which they adjudicate. I believe that NCC is on the right track, and if this happens, we're going to have certified justices across courts. It's going to be basic, certification, intermediate, and advanced. And tech, we're very familiar with certification, so it's something that, if taken on, even justices within their lordships environment would be supporting others, formally and informally, and over time we're going to see the quality of our jurisprudence improve. The other thing I think is that we should encourage the development of a trusted third-party network. Trusted third-party concept is very common in tech. So you get a private entity and give the private entity conditions for providing services that government ought to have done by itself, but constrained maybe because of technical capacity or funding, and then find a business model enabling the technology company to recoup its expenses and make a reasonable profit. So why can't we have these kinds of people build networks connecting our courts, right? The other is the evidence system. It is very strange that it's only in technology that we manage admissibility very tangentially. We just say, oh, if you can assure me that the system upon which this information is printed out of was in normal working condition and you were in control over that system, then I trust your printout. That's the protocol, right? Now, it is laughable, to say the least, that that should be the standard for electronic evidence in our country. It is laughable. And that's why I've chosen the evidence system as our hackathon. So let me skip that, because I'll come back to it when I'm discussing the hackathon. We should also, as part of this reform, insist on transforming the lower court as well that we've mentioned. And of course, the legal hackathon. Before we go into the hackathon, my lord, I want to insist that even if we fix everything that I discussed and we still have this attitude in our regulatory environment where we don't reflect our laws with trends in technology or development in technology, will still be far behind. Now, Lord, in maybe 15 or so years ago, the world achieved what is called technology convergence, where telecoms, broadcasting, and IT converge in a single system to provide services. The response by so many countries was also to converge their regulatory authorities. The US has, FCC. The UK has Ofcom. If you look across Africa, you're going to see so many countries did this. But in Nigeria, we still have telecoms by NCC. We still have broadcasting by NBC. We have NITDA doing IT. For some reasons, we keep the legal and regulatory environment disparate and separate while the technology itself has converged. Until we fix this, my lord, we're still going to have a lot of challenges. We're going to have operators going across these sectors and paying huge amount of money to get licensed, because of which they're going to transfer to all of us citizens. And there are so many pockets of services that cannot be developed because of these challenges. MTN recently announced, I think yesterday or day before yesterday, that they're going to launch a television service. MTN got this license, the very first license, which expired and was recently renewed in 2015 at the cost of $171 million. A telecoms operator getting a broadcasting license. So we're using licensing to achieve that convergence instead of, doing it statutorily, right? So that's a challenge that must be fixed. And then the last time I spoke about this, someone said, oh, but we have the digital economy bill. Of course, the digital economy bill cannot solve this problem. The digital economy bill is looking at statutorily providing technology service coordination. And it is leaving the infrastructure guys completely out of it. The digital economy bill is about NITDA. So NCC is not included, NBC is not included. So the issue of tech convergence is still, to a very large extent, vacant. So before I go into the hackathon, I'm going to conclude that we would not achieve e-judiciary in Nigeria by modernizing our reported cases. Did you move? Next slide. Yes. So Nigeria will not achieve e-judiciary by modernizing reported cases. We would only achieve e-judiciary by transforming judges, justice institution, technology architecture, evidence system, and innovation frameworks into a coherent digital justice ecosystem. That's how it works. So my lord, that's officially the end of my presentation, but because I said I'm going to challenge us with a hackathon, so let me suggest what we should do, because I said with AI, all you now do is build. Let's build something. That's the demand and reality of AI. So let's attempt to build an evidence management system, digital evidence management system for our judiciary. So because before now, in fact, I used to say that algorithm change one myth into a reality. You know how they used to say, my lord, you cannot find a needle in a haystack? Yes, you can with technology. So the other thing, algorithm and tech change, AI change, is that seeing is no longer believing. So that's the second one. But the fact that you see my picture, the fact you see my video, someone recently said a gentleman who is a social media influencer posted a video where the president was making some admission saying X, Y, Z, and it turned out the guy did not post the video. The information wasn't even true. It's not accredited to the president. The young man that did that was later allegedly arrested by the police, and so on and so forth. So what is trust? What your eyes tells you now, is it trusted? If this is the challenge, what kind of evidence management system does the court need to tackle this? So that's our challenge. How do we build an evidence management system that would incontrovertibly dispose of the inquiry as to the originality of a document as a condition for admissibility? Because evidence can now be manufactured, and It's not like in the past where you can see fraud, you get someone to do signature check and all of that. It is now so believable that it is not different from the actual information. So for those who are very comfortable with the standard of electronic evidence admissibility in court, what if the files and the records we're looking at is about 10 million records? Do we print all those as well? Where do we take it? Where do we keep it in court? Right? You know, so what if it is a long story that goes into hours of discussion? What if that is the evidence that is in issue? How do we bring that to court with the state of our Evidence Act today? You know, so what I'm proposing, and how many legal tech entities are here? Apart from Law Pavilion. Oh, you are, okay. Now, the audience may not be robust enough, but I have it on good authority that a technology-oriented government institution is willing and able to fund this project if we can have young Nigerian lawyers working with legal tech companies to build a dedicated evidence management system for our courts. You can take it to the bank. So all we need, what I want to do today is to have a few people take the lead, that they're going to take this up, they're going to go get the legal tech companies, and we're going to work on this as a project. What we're going to aim at is to say, if the issue is AI, our evidence system is also AI oriented. So a picture that is manufactured would not pass through our court without it being spotted, because you can dissect pictures at pixel level. You can even get sources of a picture, you know, unraveled, so you can see that, look, this picture came from 200 sources and joined. You can even get the technology that put them all together if you have the right system of authentication. Now, this is the nature of evidence. Are you on the? Yes. This is the true nature of evidence. Evidence is about creating, preserving, collection, chain of custody is important, storage, discovery, verification, analysis, and then presentation in court, and then archiving it. This is the full gamut of electronic management system. Tell me if your sense of the current evidence system as it affects digital in Nigeria covers this. I doubt that it does. So this is what we need to build. And someone raised their hands when I was asking for tech lawyers. I did that purposely because I wanted to see with whom we would work. She did not get the answer right, so she did not get the $100, and her colleagues did not. So I would conscript the person that won the $100 prize to be part of this team, but I'll get the identified tech lawyers to be part of the team. We're going to work together and secure the funding and get a tech company to work with us to start with this project and make sure that we leave for the country a fully fledged digital evidence system that we can use for our judicial systems. So that is it for me, my Lord. Thank you very much.
You can do better, you can do better. Please give him a rousing ovation as he takes his seat. No, there are moments when a speaker does more than present ideas. They arrange assumptions, they challenge comfort zones, they force us to imagine possibilities that we had not previously considered. This is what the six-pack framework presented by the keynote has been able to achieve this morning. So would have to proceed quickly to the next line of action. You know, there's a saying that when vision meets experience, then wisdom emerges. So we have instances where, or more like a growing concern, where we have lawyers use AI tools to draft court processes, especially legal arguments, and we'll realize later on that they are citing fake cases, fake statutes. And we also have instances where some courts still take proceedings down in longhand, type it into a computer, then, but still, before you get the CTC, you would have to endure the bureaucratic registry. So how can we use AI to fast-track justice? To reflect on the keynote and some of these concerns, we turn to a distinguished jurist whose perspective is particularly valuable at this critical moment. And we are pleased to welcome upstage the Honorable Administrative Judge of the Federal High Court, Lagos Division, Honorable Justice Ayokunle Faji, to give his reflections on the keynote. Can you please give him a round of applause as he takes the podium?
Please sit down, please sit down. It's quite intimidating to see you gentlemen stand up as I'm being led into an examination hall. Let me start by thanking the organizers for inviting me to comment on Mr. Udotai's paper, which for me is highly educative. My chief judge also permitted me to come, and through this medium I also want to thank my Lord for permitting me to come. The paper is well-rounded and has raised questions that are pertinent, and I think the recommendations made are sound. I would just add that probably we could run some form of consultation with jurisdictions that have successfully implemented these systems over time to guide the outcomes of the hackathon, just to prevent redundant effort. The paper is eye-opening. We're talking about technology and law and the intersection between law and technology, and how this will impact, or how that has worked out in the judicial sphere. We're looking at how ready or how well-equipped the judiciary is to address and combat the challenges of modern technology, particularly artificial intelligence. I agree that basically digital or technological literacy is key. It's a judicial necessity, but what will be the minimum standards? Mr. Udotai has spoken about how to train judges in certain areas, how data is transmitted. The chairman of the branch had told me that I should just say one or two things about why it appears I'm interested in this area of law and how I started. I think that as a child I was very, very inquisitive, and that inquisitiveness has not left me even as an adult. But of course, anybody who has seen the transformation from the old NITEL system, where you would have to go to NITEL to go and queue up to make a phone call, or where you had to go to NITEL to go and send emails, and you had boxes where you could go and collect your emails from. And then you now see the transformation we now have. You can do everything from a small box in your hands. That should put on inquiry as to how this will impact lives generally, and how this will impact your job. So I got interested somehow, and I would not say that I'm very, very much savvy. I would say that I'm just inquisitive and I'm just interested in that area, and that is what has made it possible for me to at least keep thinking. So there's the need for us to understand the nature of technology, and that is probably one of the reasons why I'm here standing before you, even though I am a judge. And we must be able to visualize the various concepts we have in the area of cyber life. So I look at the world as maybe a house, and you talk about hacking. Equivalent is breaking an entry, similar to what you see every time. So my own thesis is that for everything digital, there is a physical equivalent. So if you're able to put that at the back of your mind whenever any matter comes up before you, then you'll be able to understand how it actually is and be able to see that yes, it's technology, but it is still something that is real, and then you're able to extrapolate and apply your wisdom in attending to it. I also agree that we need to have a judicial ecosystem, not just silos or digital islands in an analog ocean, which seems to be what is going on presently in our judiciary. And I'm very proud to stand here and say that on the 27th of April, the Federal High Court launched its e-filing system. And that as of today, we have had about 363 cases filed on that platform. So from my phone here, I am able to access cases that have been filed. I'm able to assign them. I'm able to read my own files. I'm able to reassign the cases. I can imagine the trouble I have been saved of having 100 files in my office and having to open every one. I would say that on the average, we have about 16 cases filed on the e-filing platform, and our target as a court is to ensure that these cases are signed within 24 hours of their being filed. We do have our testimonies, and we would exercise our bragging rights by saying that we've had commendations, particularly from the EFCC. A case was filed at 5:30 on a Friday afternoon. It was assigned it was filed, uploaded, and then the lawyer was informed that your case has been filed. It was assigned on a Saturday, and by Monday afternoon, a conviction had been secured. So that tells us the power of technology and the reason why judges must have some basic knowledge of how technology works. So my colleagues are able, in fact, Justice Kala just came back from Saudi Arabia and said, "My Lord, I've been seeing the cases you are assigning to me. I've been reading my files." So that's the power of technology. But can you then imagine that being applied in every facet of the law and order situation? Mr. Odota spoke about identity, information, NIPSI, not being interoperable with the judicial system, for instance. That is a major challenge. I think we still have this issue of areas of influence, particularly in government institutions. And that is one of the challenges we would have in operating a judicial ecosystem. I tried to put down a speech, but I have persuaded myself that it would have been better if I had not written a speech. and just listened to Mr. Udotai, because now there's so much confusion going on in my head. But I hope to be able to get through this. So the other aspects of being able to create a credible e-judicial ecosystem is probably the absence of a political will. Now, the judiciary is an arm of government. One of the problems with having this ecosystem basically is finance. The NJC currently has a Judicial Information Technology Committee headed by the Chief Judge of Borno State. The e-filing system that has been done in Lagos, for instance, Federal Court Lagos, for instance, is already in operation too in Borno, in Niger, in Taraba, in Bayelsa states and Delta states. It is not that the judiciary is not ready or desirous of having technology applied on a very good basis, but then there are issues of finance. And of course, I think political will. So do we understand the technology we interpret? Do judges actually understand the technology? I was sharing my challenge the other time with not being able to access my email because too many apps were open. I had to call my IT guy to come and say, it says, my Lord, next time, just flip and do all that. So that is the level of knowledge that some of us judges have. And don't forget that there are quite a number of judges that are not Gen Zs like most of the people in this room. So we are supposed to know and understand the technology behind all the steps that come before us. We understand technology not necessarily in depth, but also understand the mechanism behind it. Mr. Udotai has given us quite a number of ways of doing that. So if lawyers, as in the matter case, if lawyers can be misled by AI, how much more judges? We all have the same kind of legal training. And the question also arises, how do we discover or know AI-generated evidence? Section 84 just says any document generated from a computer, certain conditions must be fulfilled. How do you then know whether what is being brought before you is real or fabricated? How do you know whether the voice you are hearing is the voice of Justice Faji or the voice of somebody else? How do you even know whether the video of me that you are seeing is the correct one? Those are the areas where I think as judges we need some more enlightenment. And that is something that can be achieved through the 6-point plan that Mr. Udotai propounds. So I also raised the question, how does a judge answer a technological question that has legal consequences? He has said that judges are well trained in the law. How well trained are we in the technology that we are asked to interpret and apply? Basic questions. For instance, how does telecoms work? How is interception conducted? How are bank accounts hacked? Of course, the practice these days is that on a Saturday afternoon, banks just get glitches, and then by Monday, money is about to be moved. So Monday mornings, we find that there are a lot of urgent applications that have been filed. If the judge doesn't understand that this is something that requires urgent attention, and that the movement of the money ought to be stopped or reversed, that is a little of the technology, but then he must be able to play it out in his mind and know exactly what he is stopping. Generation of metadata, and of course, Mr. Udotai, the basic focus of this discussion is the intersection between law and technology, particularly where the dispute involves technology. Now, we've spoken about the court, the judiciary, the justice. A lot of people, we think that court is a place, and that's why most of the time the involvement of technology in the judicial process is not appreciated. The court is a service, not a place. So insofar as you're able to get that service, it doesn't matter where that service is proceeding from. And that is exactly the idea behind an e-justice ecosystem. And that is the perspective from which we should look at this. We've spoken about the judiciary as a system. We've spoken about justice as an outcome. All this doesn't need, and he also spoke about the Chinese courts where you are able to go to enter the court. In fact, in some Chinese courts, you don't even see human beings, you just see systems. And go and then you simulate your dispute, and the system advises you. So, but digitization of the courts does not necessarily have to transform into justice. So you have spoken about the justice ecosystem, the police, the prisons, and that reminds me that, for instance, well, we are doing these things in bits and pieces, and that may be due to the system of court administration that we have. I think personally that the administration of the judiciary should involve a bit more of professional managers who would decide what kind of infrastructure the judiciary requires, how to get it, the kinds of business models to use in getting the infrastructure installed, and who will run the infrastructure, who will keep the information, how the information is secure. So those are some of the things. So I think really, at the end of the day, we should have some kind of paradigm shifts. For instance, in Abuja, the courts in Abuja have direct links with the prisons. So it's possible for a judge sitting in the federal court in Abuja to conduct proceedings involving somebody in the correctional service. Of course, you have spoken about the magistrate courts. I'm not sure, I have not practiced law now for 24 years, but the information I got, if I'm right, please let me know, is that the magistrate courts in Lagos are digitized. Is that true? But of course, the entire judicial ecosystem is not. So, so there's need to transform the entire justice ecosystem, and we need then to understand the architecture of technology. What we are doing now is just to create applications. When we were discussing the issue of the e-filing at one of our town hall meetings, the one we held in July last year, one of the questions was, this information that you are generating is large. Where are you going to keep it? Is there no possibility of a third-party interference to just throw something into it, and then by the time, and like somebody said, technology is very dangerous. If all you just need is a downtime in terms of internet service, and all sorts of things could happen to your information. So we need to understand these 4 layers of the technological infrastructure, and then understand where we are, and start planning how to develop the other levels, proper infrastructure, networks, systems, and applications. So, of course, I've spoken about interoperability. We must be, the justice ecosystem So it's not as if you have a court system that is digitized and a police system that is analog. So it's not just, we're just not talking about the courts alone. We're talking about the entire law and order system, the entire justice system. And that shows us the enormity of the challenge we are facing and the reason and the need for us to actually set to work. The hackathon on the evidence aspect is a very, very good idea, because it is important that to remember that seeing is no longer believing. And it was a truism until AI came, but the dangers of AI are beginning to manifest. Should judges use AI in arriving at their decisions? Maybe some aspects of their decisions, maybe the summary of the facts, summary of the arguments, but I really would not ask AI to think. I won't ask, because AI doesn't have the emotive aspects of human nature. AI did not see the witness. AI did not see the evasiveness of the witness. AI did not see the innocence of the witness. AI did not see the hesitancy of the witness when he was being cross-examined. These are things that only, for me, only human beings trained in that area from experience can do. Of course, I do not think that our Evidence Act has gone far enough. When it comes to electronic evidence, you must know how to, first of all, access it, how to preserve it, how to store it, whether you're going to block it, put it in an evidence pouch, and then block it and then copy. Have a hash value and have a copy of the of maybe the phone that you are seizing, and up to then the analysis, the presentation, and the archiving. Those are things which I think evidence law should look at. It's not a matter for memorandum, or it's not a matter of regulations, it's not a matter of practice. So at least when it comes to electronic evidence and technology, we are able to have some kind of objectivity. The judiciary transformation policy, again, we have bodies that are regulated by law, established by law. The National Judicial Institute is a body set up to train judges. So when it comes to technology institute in the judicial sphere, my own suggestion is that it's a very good idea, but probably think about having a department at the NJI, and then we then ensure that at least we give as much knowledge. Justice network, we need to have something that the justice, law and order industry alone will use and can be protected and be safeguarded. Digital evidence system, well, we prioritize the lower courts because that's where the majority of the work is done. And the National Legal Tech and Justice Innovation Challenge. It's a competition, in February, I was at the hackathon in Abuja, and I did see that, and I was also at the one they had in June last year. And I did see that there's a lot of talent in Nigeria. A lot of young people were given the opportunities to come and give us concepts and programs that we could use to enhance the system of administration of justice. So I think that it's a very good idea. We're talking about digitization of the judiciary, of the e-judiciary. We have what we call the Nigerian Case Management System. As it says, it is Nigerian Case Management System. So it affects only the judges, the judiciary. Case management system, I'm not sure that involves the infrastructure. I'm not sure it involves the network. I'm not sure it involves the system, but I know it's an application. So how does that assist us in this large ocean called judiciary, e-judiciary? Artificial intelligence is an opportunity. It's not only a risk. And of course, what about digital inclusion? What about those places where we still don't have sufficient network? Of course, that is also part of a defective technological architecture. Human and cultural factors, human elements, and so I'll just conclude that the paper correctly identifies the need to move beyond digitizing courts towards the broader goal of digitizing justice. It presents a bold vision for the future of the Nigerian judiciary and offers practical recommendations that deserve serious consideration. However, the next phase of the conversation should focus on critical implementation issues, including funding, governance, inclusion, change management, and practical execution strategies. The vision outlined in the paper is both compellable and achievable, but its success will depend not only on technology, but also on institutional readiness, sustainable financing, effective governance, and the collective commitment of justice sector stakeholders to embrace change. As the saying goes, digital transformation is 20% technology and 80% people. Without the buy-in of judges, lawyers, court personnel, law enforcement agencies, and policymakers, even the most innovative and well-designed digital systems will struggle to achieve their intended impact. I want to end by saying that today I'm throwing a challenge to the NBA Eti-Osa. Since you've come to do the talk, I think you also should start thinking of how to walk the talk. You should take the initiative and be in collaboration with Mr. Udotai, particularly as regards the hackathon is thinking about as regards the evidence in technological matters. I want to finally end by saying that I must say that coming to speak here is a privilege. We are all lawyers. The NBA is our umbrella body. In whatever way we can assist one another by coming to share thoughts, we must always be ready to do so. Mr. Udotai has come here to spend so many valuable hours to share his knowledge with us. I want to thank him also for sparing the time. As you can see, it is a learning process. Even I had to stutter a few times when I was making this speech. I don't stutter when I deliver judgments, just for you to know how different this has been for me. It's been a 24-hour crash program for me, but having done that, I think I should to accept my words of gratitude and to accept my humble declaration. It's been a huge privilege speaking here, and that I'm very grateful for the opportunity. Thank you very much.
Keep clapping.